Hi. For those of you who don't know me, I'm Howard Elgot. I'm a fairly senior member of Park Lane Plowden, pretty senior, it's fair to say. And one of my kind of specialisms is mental capacity, of which I've spoken on mental capacity quite often. And I've often been in cases where mental capacity has been an issue. And there aren't that many cases in litigation where questions of mental capacity have been fought out. Although I dare say there may be in the Court of Protection, but the Court of Protection is not my area per se. I don't do Court of Protection cases. Mental capacity. Mental capacity is all about the brain. I thought that was a nice, jolly picture to start with, because let me tell you in advance, we're not going to get many other jolly pictures. What we are going to get, I hope, is some basic guidance. And what I'm trying to present is a practical guide, because time and again, I do come across cases where the question that I ask my solicitors is, have you considered whether the claimant has litigation capacity? And quite often, the solicitor hasn't considered it. And quite often, but not always, the claimant doesn't have litigation capacity. Now, although I'm very pleased that you've decided to come and listen to me, you should also look at the Law Society guidance that was published less than a month ago, called Working with Clients who May Lack Mental Capacity. It's easily available on the web, and you can click through when you get the slides. The Law Society says it's less than a 1-minute read. I was quite surprised when I saw that, and it isn't a 1-minute read, unless you're a very quick reader. But it is worthwhile, and I think in combination with the slides from this talk and reading what the Law Society say, then you will know the majority of what you need to know, but not everything. Okay, right, on to the next slide. Let's start with some pretty basic stuff. The following principles apply for the purpose of this Act. It's the Mental Capacity Act 2005. And we start with something that everybody knows and that I think nobody understands. It says, a person must be assumed to have capacity unless it's established that he lacks capacity. Well, in my opinion, the presumption of capacity is much misunderstood, sometimes even by doctors. Because like most presumptions of law, the presumption is subject to evidence to the contrary. And often with presumptions of law, you don't need much evidence to the contrary. And so my heart tends to sink when I see medical reports that blithely talk about the presumption of capacity, as if it means that the doctor doesn't really have to think properly about capacity. 1.3, a person's not to be treated as unable to make a decision unless all practicable steps, not just a few practicable steps, but all practicable steps to help him to do so have been taken without success. That's an enormous burden on a solicitor. and on counsel. But the law is the law. Get this in the right direction now. Okay, section 2. People who lack capacity. I mean, it's pretty obvious that that relates to an impairment of or a disturbance in the functioning of the mind or brain. And a person lacks capacity if he's unable to make a decision for himself or herself in relation to the matter. The impairment or disturbance can be permanent or temporary. 3 is jolly interesting, but shouldn't trouble lawyers too much. And 4, it's got to be decided on a balance of probabilities. So, I mean, interestingly enough, you've got a situation where section 1, there is a presumption, but section 2, the decision has to be on a balance of probabilities, just to prove that you don't need much evidence to show that the presumption is not something that you should be looking at that closely. Next slide. So what does an ability to make decisions mean? A person's unable to make a decision for himself if he's unable, A, to understand, that's obvious, B, to retain that information, that's not so obvious, C, to use or weigh that information as part of the process, which is only obvious when you think hard about it, and is really, I think, part of the meat of the matter. I mean, obviously, if somebody is of a vegetative state, they can't do any of it. But the question of whether they can use or weigh the information is really quite a difficult question. And it's that, and that's the kind of question that you'll need a neuropsychologist, neuropsychiatrist for. But then also 3.1d, which I've come across in practice in relation to a case. I think I've got an interlocutor hearing in it next week. He probably ticks every box, but he can't communicate his decision appropriately. I do not see in that particular case, just looking to see if the particular solicitor is on the attendance list. I see not. But I mean, a solicitor needs to be able to communicate properly and adequately with his or her client. And there's no getting around that. I mean, and what had been happening in that case is that all the communications had been with the person's wife. And no attempt had been made to communicate with the client, who is in sheltered accommodation and doesn't, to me, have the level of communication that's going to be necessary in order to conduct quite serious litigation involving why he's in the state he is in the first place. Okay, next slide. A person's not to be regarded as unable to understand the information if he's able to understand an explanation given in simple language, visual aids, or other means. Again, that's obvious, and so good luck with that one. The fact that a person's able to retain the information for a short period doesn't prevent him being regarded as able to make the decision. Yeah, well, there we have it. But how long is a short period when you're trying to explain something? For instance, like I don't know, the Williams and Bermuda hospitals, Rennie and North staffs. Anyway, and the information relevant to the decision includes information about the reasonably foreseeable consequences of deciding one way or another, or failing to make the decision. I mean, that's important in relation to having litigation capacity for settlement. Anyway, the Law Society guidance states as follows. This is, they say, up to the minute. The key question is set out in the judgment of Lord Justice Chadwick Masterman Lister, which you will have spotted precedes the Mental Capacity Act, but never mind about that. And so the Law Society say, I think quite rightly, a party to legal proceedings is capable of understanding, with the assistance of such a proper explanation in broad terms and simple language from legal advisors and other experts as the case may require, the matters on which their consent or decision was likely to be necessary in the course of those proceedings. Yeah, yes, well, it's a decent rule of thumb. Can you note that the test applies to proceedings as a whole? A litigation can't have litigation capacity for say, simple liability issues. Somebody has been run over, but not complex quantum issues, Bailey and Warren. Now, at first instance in Bailey and Warren, I was acting on behalf of defendant, and I managed to persuade the Honourable Mr. Justice Holland that although the claimant had litigation capacity to settle liability, he didn't have litigation capacity for financial matters. What had happened was that there'd been a split trial, and years later, a firm of solicitors had decided that the claim had been undersettled, and said it had been undersettled without approval. Therefore, the settlement was invalid. And we argued on behalf of the insurers, well, with appropriate medical evidence, that the claimant had capacity to settle the part of the claim that he'd settled, which was liability. And the Court of Appeal in Bailey and Warren said, no, you can't. It was 2-1. I managed to persuade one of the members of the Court of Appeal that Mr. Justice Holland was right. But I failed to persuade the other two. But it didn't matter to us on behalf of the insurers, because what the court did was to ex post facto validate the original settlement anyway, so still won. But it's very important to realize then that if you can't just settle on liability with someone who is borderline incapable. If he's capable of liability, but not in relation to quantum, I'm not entirely sure that's correctly decided even now, all these years later, because the Act suggests that every step ought to be taken, and that all capacity decisions are issue specific. And so you could see why that case could have gone either way in the Court of Appeal. But anyway, the issue was said by the Court of Appeal to be litigation, not liability and quantum to be split. Why is this particularly important? Sorry, why is mental capacity particularly important? It's because You don't want to be, you don't want to get in trouble with the SRA. You might say cynically. If you have reasonable doubt about your client's capacity to give proper instructions, says the Law Society, it's your professional duty under 3.4 of the SRA Code of Conduct, etc., to satisfy yourself whether the client has capacity to give instructions. And so again, I say, if in any claim you've spent the previous 12 months just taking instructions from your client's partner or daughter or grandmother, then it may be that the reason that you're not taking instructions from the client is because your client doesn't have litigation capacity. All right, what kind of cases does this apply to? Well, obviously brain damage, head injury cases. And in relation to this, watch out for experts who do not consider capacity when reporting. Because many experts who ought to know better, I would say, will not consider capacity unless you ask them. Particularly neurosurgeons, sometimes neuropsychologists, bizarrely enough. In private, I'm happy to name names. And so if you want your expert to consider capacity when reporting, you've got to ask them. Obviously, we all know the kind of expert who doesn't actually read the instructions, but I can't do anything about that. So other cases might be cases where the client has a severe learning disability. And I mean, in other words, to need a litigation friend, you don't need to have a client whose injury has caused that. So severe learning disability, dementia, cases where the client may have serious psychiatric problems, that can be tricky. You get a rather difficult client, and sometimes you think, well, does this person actually have serious psychiatric problems? They may not have litigation capacity, and it can be highly problematical because their litigation capacity can fluctuate from day to day, from month to month. So also cases where the client's got serious communication problems I've dealt with, but it's not just clinical negligence and personal injury cases. Okay, next slide. So expert evidence. A psychiatrist or neuropsychologist is best. I mean, I kind of tend to the view that a neuropsychologist is best. If you go back to the cases where decisions have had to be made as to whether the patient has capacity or not, then interestingly enough, the decisions are made by the court listening to neuropsychiatrists, neuropsychologists, and to lay witnesses as well. And in cases like Masterman Lister and Bailey and Warren, the court gave considerable credence to the evidence of lay witnesses as well. And these cases, to decide capacity, can take 2 or 3 days. And so you need an amalgam of medical evidence and lay evidence. Now, whereas if you're the solicitor, you have to make a decision in a matter of minutes without any of that evidence. So good luck on that as well. Anyway, the Law Society guidance states, if you need to get an expert opinion, you should tell your client about any concerns you have about their capacity, the purpose of any capacity assessment, the implications if they're found not to have capacity, And when getting a medical or other expert opinion, you must provide the client's written consent or confirm they've agreed to be assessed for capacity. So we can all think of clients who would not like you to follow the Law Society guidance, of course, but you have to do it. If you've got any, you've got to tell your clients about any concern you have about their capacity. How to make friends and influence people. Anyway, there we are. That's the Law Society guidance, and I've put it in quotes just to prove it. Next heading: if your client objects to an assessment. I told you this was a practical guide. If they refuse, you'll need to decide whether you wish to rely on your own opinion of their capacity, and must explain to the client in writing you're unable to act for them or continue to act for them without a report. And you must also explain the potential legal consequences, such as a subsequent challenge and the transaction being set aside by a court. Now, that was Bailey and Warren, because once Bailey's solicitors and counsel had lost in the Court of Appeal overall against the insurers, they then set about suing the solicitors. And so these are potential legal consequences. And anyway, you've got to explain all this to the client. All right. Now, you can all think of difficult cases. I've got an ongoing case at the moment from which I have taken what follows, but I've actually chopped it up in such a manner and anonymized it that you'd have to be really, well, again, I see the solicitor is not amongst the people here, so I don't think anybody could possibly spot what this relates to, because of the jigsaw and the anonymization I've done. But this is more or less what the neuropsychologist says. His physical difficulties, cognitive limitations, and emotional lability, including high levels of anxiety, mean that XX will require special measures in place to enable him to give evidence, including giving evidence via remote link. Well, that's all right, we're all used to that. And being supported by an advocate and/or an intermediary. What you may say is an advocate and an intermediary, because an advocate is a term of art in this. An advocate doesn't mean somebody who's got an advocacy qualification. And then it goes on, although XX has litigation capacity, he will require the support of an advocate during any official meetings. What's an official meeting? Answer, I've no idea. I assume it means any meeting between the client, the solicitor, the barrister, medical expert. I don't know. I've only just seen this. I'll have to think about it. But this is, but the first thing is to find out what an advocate is. Now, again, not many of you have put your cameras on. I'm so thankful for the people who have. So I can't tell I can't ask the question, which is, does anybody actually know what an advocate is in these circumstances? Anyway, this is from an NHS document called "Someone to Speak Up for You" (advocate). And what I've reproduced is the passage, how to get an advocate. You can contact your local social care services. There are various charities listed there, and you can contact your local Age UK if it's somebody who's elderly or has got dementia, I think. And they may or may not, at a price or not, provide an advocate. As it happens, the client of mine that I've been talking about seems to have had an advocate at one point, but now doesn't. So this is, don't forget, this is not me telling you what to do. It's me and the Law Society telling you what to do. Okay, all right. This is something which I think I can give practical advice upon, even though I'm not a cost expert, and I don't think by and large, I do CCMCs, but cost is not the basis of my practice. But Kerry Underwood, who you will all know, has written an excellent blog post also this year entitled Mental Capacity and Retainers and Conditional Fee Agreements, Problem Solved. And he suggests, based upon counsel's opinion, that at worst, a CFA with a person without litigation capacity is voidable rather than void. So a settlement of a claim on behalf of somebody without litigation capacity is void. I mean, bereft of life, it rests in peace. It is a non-settlement. You don't have to apply to set it aside, even. It's as if it didn't exist. But a CFA, according to Kerry, is at worst voidable rather than void. And Kerry, through the counsel that he'd instructed for this, I think, also argues that it might be possible that a CFA is a contract for necessaries, which you'll all remember from law school, if not from anywhere else. And if it's a contract for necessaries, you should be okay. But this is not my area at all. What I can say is that common sense dictates that you should have a CFA on a joint and several basis with a potential litigation friend and the client to cover all your bases. I mean, I think that's just a matter of common sense. And it may be that if you've got a CFA with someone who doesn't have litigation capacity, then it can be amended, can't it? Or replaced, because there's nothing wrong with including costs already incurred in a CFA. I think that's my understanding. But again, don't rely on me for cost matters. But yeah, I mean, that is so important, isn't it? Whether you're going to get into trouble if you sign up somebody without litigation capacity. Let's move on to hopefully something I do know more about, which is litigation friends, part 21 of the CPR. So usually you would expect family, friend, or even the official solicitor as a litigation friend of last resort. I mean, I could do a whole talk on what you should do if you feel as a solicitor the current litigation friend is so obstructive that you would like to get rid of them because they're getting in the way of the conduct of the case, and replace them with the official solicitor. I mean, that might be a talk for another day. It's only ever happened to me once in my whole career, but it's kind of thing that is good to know, I think. So obviously, most of you will know that you don't need a court order. And the 2141, you don't need me to read out. 24.2 it might be important. A deputy appointed by the Court of Protection with power to conduct proceedings is entitled to be the litigation friend. I think that means that a deputy appointed by the Court of Protection does not have power unless the appointment specifically says that the deputy does have power to conduct litigation. And I don't think that there's any authority on that subject, by the way, because I've tried to find it in the past and have not been able to. But I think basically, if there is already a deputy for some reason, I don't think that necessarily gives them an absolute entitlement to be the litigation friend if somebody else wants to be it. So the test is quite important, because 3A, they've got to be able to fairly and competently conduct proceedings on behalf of the child or protective party, have no adverse interest, and undertake to pay costs. Again, you could probably have a whole hour's lecture on the liability for litigation friends for costs. 3A is particularly important if you want to try to replace a litigation friend, because you have to argue that the litigation friend can no longer fairly and competently conduct proceedings. And there is a slew of High Court and Court of Appeal decisions that one would need to look at in relation to that. Okay, all right. This is one that I've already spoken about to some extent. Litigation capacity is not the same as financial capacity. See Bailey and Warren. A litigant may have litigation capacity, but not financial capacity, and vice versa. See Bailey and Warren. If a litigant does not have financial capacity, and the claim is a substantial one, you should make a claim for Court of Protection deputyship costs, supported by expert evidence as to what the costs are going to be, because in a substantial case, they could average out at £12,000–15,000 per annum in a substantial case. That's a rule of thumb average, because each year tends to be different, as you will find out from your expert. But what is really important, I mean, all that might be obvious stuff. The next bit is not so obvious, that even if the defendant has not caused the incapacity, the receipt of a substantial sum in damages will usually trigger a claim for Court of Protection deputyship costs. While I've been talking, I've been trying to think of whether there's a cutoff. I think under the new rules, a sum of even up to £100,000 doesn't have to go into the Court of Protection or otherwise be administered. I think it's just recently changed to £100,000, and so it can be dealt with for someone with mental incapacity in the same way that you could deal with a child's damages. But certainly over 100,000, you may well have a decent claim for court of protection costs. Again, I don't think there's any authority on this. So I might be wrong. I might be wrong about anything, really. As I always say, that one of the marvelous things about counsel is that you can say, well, this is my opinion. Might be wrong, probably isn't, not normally wrong. Compromise. Where a claim's made by or on behalf of a protected party or against a protected party and so on and so forth, then no settlement, compromise or payment or acceptance of money paid into court, or Part 36, because there's a Part 36, because the Part 36 actually says so, shall be valid without approval of the court. Everybody knows that. Not everybody knows that any voluntary interim payment is invalid without approval of the court. So if you get early on from NHS resolution £100,000 interim payment just to keep some kind of care regime going while the case can get sorted out, it's invalid. You can't deal with it as solicitors without an order of the court. I mean, the preponderance of people here, I recognise as probably doing claimant work, but I also recognise people who are doing defendant work as well. And the defendant, solicitor who is on the ball, ensures that their client doesn't pay out money where the payment is invalid, because that can have consequences too if the money is squandered. And no, neither NHS resolution nor the insurance industry nor a claimant solicitor wants to be on the wrong side of litigation when interim payments that have not been approved have been made and the money's been dissipated incorrectly. So that's really quite important. So let's start. All right, where before proceedings, etc., and the sole purpose of proceedings is to obtain approval, you've got to use Part 8 and include a request to the court for approval. Well, I think everybody knows that. But what if you settle a claim on behalf of a claimant who didn't have capacity? Now, I've alluded to this quite a few times already. And I'm kind of an expert on this. I've probably been involved. I don't know. I've probably been involved in as many of these cases as anybody. And I've acted on all sides as well. I've acted for claimants. I've acted for allegedly negligent solicitors. I've acted for insurers. I don't think I've acted for NHS resolution in relation to one of these cases, but basically they're all the same. And if you do settle a claim on behalf of the claimant who did not have capacity and there was no approval, notify your insurers. And last year I spoke at a national PNLA conference, on these kind of claims last year. And if you want a copy of my talk, which is entitled An Otherwise Intractable Situation, the Conundrum of Incapacity in Solicitors' Negligence Claims, then contact me or my clerks. And I assume that, and don't tell the PNLA, because I'm not entirely sure who owns the copyright in it. I think I do, but anyway. But I'm not a copyright lawyer. Now, what we don't like in law, do we, is are intractable situations. So I think I need to tell you a bit about this case, which was reported, I think, rather peculiarly in road traffic reports of last year. And although it did center around a road accident, the fact that there'd been a road accident it was neither here nor there. It could have been any old accident, including a medical accident. So Evans and Batesh partnership was a decision of the Master of the Rolls in the Court of Appeal. And I acted for the solicitors in this one. So I acted for the Batesh partnership. And there were claims against the Batesh partnership and against counsel who'd acted, who were separately represented. And so the facts were as straightforward as they could be. Ms. Evans had accepted £100,000 by way of Part 36 on behalf of Mr. Clancy's insurers, Mr. Clancy being the driver. And she had a conversation between herself and her solicitors on the 8th of November 2011. And neither her solicitors nor her barrister advised her to accept the offer, but she gave instructions to accept the offer, and the offer was duly accepted. I don't know, you can probably guess what happens next. Some years later, Ms. Evans consulted new solicitors. The new solicitors sought new medical evidence. And the new medical evidence was to the effect that Ms. Evans had suffered a traumatic brain injury in the accident, and she probably did not have litigation capacity at any time following the accident. And importantly, she didn't have litigation capacity as at the date of acceptance of the defendant's Part 36 offer. I mean, it's fair to say that on behalf of the solicitors and on behalf of the barrister, we neither accepted nor didn't accept the allegation that she didn't have litigation capacity. So she, as far as we're concerned, and we didn't have our own evidence, as far as we're concerned, she may or may not have had litigation capacity. So, and it was alleged that the claim was very substantially undersettled. The allegation was it had settled for 100,000 and it was worth 2 million-ish. It wasn't the worst brain damage you've ever seen, but it wasn't great. So the new solicitors, acting through a litigation friend, issued proceedings in professional negligence against the Batesh partnership, who because of the way it was drafted, were the first, third, and third to sixth defendants, and against the barrister, the seventh defendant, but not against Mr. Clancy, the negligent motorist. Again, if I could see you, I'd ask you to put your hands up and ask whether you think that they should have sued the negligent motorist first. Well, we argued that the standard practice in the claims was for a claimant to pursue the original tortfeasor first. In other, as was done in Bailey and Warren and in Dunhill and Bergen, a very famous case. And And what's more, it was my argument in the Court of Appeal was accepted that there was no previous case reported or otherwise that was known to any of the parties where a claimant who alleged that he or she didn't have litigation capacity as at the date of a settlement had chosen to issue proceedings against his or her legal advisors to the exclusion of the original tortfeasor. I mean, to put it bluntly, if your claim against the Ambridge District Hospital Foundation Trust has been settled for 100,000 and it's worth 2 million, if the person didn't have litigation capacity, then you would ordinarily expect the claimant to reopen the claim that hasn't been approved against the Ambridge District Hospital Foundation, NHS Foundation Trust. And that's what the claimant didn't do in Evans. And so we applied to strike it out, both the solicitors and the defendants. I mean, it was really badly pleaded. It was woefully pleaded, the solicitor's negligence claim as well. So that helped make the decision to apply to strike it out. And it was struck out by the High Court for reasons which, if you would like a copy of my talk to PNLA, you will find out. But anyway, amazingly enough, that notwithstanding that this went for 2 days in the Court of Appeal, we settled on day 2 on the basis that we were prepared to give what we'd not been prepared to give in the past, which was an indemnity to the claimant against the costs of pursuing the original tortfeasor. It is, I mean, interestingly, we had refused to do that in the past, but the Court of Appeal, and particularly the Master of the Rolls, can be very persuasive when invitations are being given to the respondents to reach a settlement, albeit in the middle of day 2 of the Court of Appeal hearing. And once we'd settled, much to our surprise, the Master of the Rolls said, "But even though you've settled, I want to give a judgment because this is a really interesting topic. Mr. Elgot, please, can you finish your submission?" So I had another hour in the Court of Appeal with the Master of the Rolls, already knowing what the result was, which is a rather odd experience. And in the judgment, Master of the Rolls explains how the settlement had been reached and said it was a good job that it had settled because it was the failure to join the negligent motorist had produced an otherwise intractable situation. And so, oddly enough, although they've given judgment, there still is not much guidance as to what to do in these circumstances, what to do if, and so there's not much guidance to the claimant, not much guidance to the solicitors or counsel as to what to do if they're sued, because it's an otherwise intractable situation. Anyway, there we have it. My clients were happy with the outcome. I think the barristers, insurers were happy with the outcome, and the claimant was happy with the outcome. I have absolutely no idea what is happening to the case that has presumably been brought against the tortfeasor, against Mr. Clancy's and his insurance. But I do know that about a year on, they still haven't issued proceedings against them. But anyway, I'm out of that now, for the time being, at least. Okay. Next slide as we come to the end. Is a court approval a defence to an under-settlement claim? Amazingly enough, the White Book says it is, at 2110.2, and cites Evans and Batesh Partnership as authority for this. This is absolute tosh. Fortunately, the first supplement corrects the error, but doesn't actually say, oh, we made a big mistake. It was an error. It just says delete some paragraph, putting a new paragraph. No, I mean, basically the situation is that a judge can only approve on what he or she is provided with. So, and if the judge is provided with tosh, then you will get an approval based on tosh, and the approval doesn't stop you being sued. Anyway, the White Book appears to have come into line on that. Finally, I think this is the final one. No, there we are. That's the final one. Coles and Perfect. This is really important, practically. If in doubt about litigation capacity at the point of settlement, apply for an approval. The court is prepared to approve a settlement, even if no one is sure whether the claimant has litigation capacity or not. See Coles and Perfect, a decision of Tier J. I mean, this is a well-used adjunct that I don't know if it's well used by other people. It's certainly well used by me, and it prevents delays and unnecessary costs, and it may also prevent you from being sued, because provided you don't put tosh in front of the judge doing the approval, if it's approved and there's no and the client doesn't have litigation capacity, great. If the client does have litigation capacity, great, no one cares. The defendant is still going to pay the costs of it. The defendant is not going to argue, don't do it and I won't pay your costs. I mean, unless I'm giving insurers or solicitors or NHS resolution solicitors funny that think that they not pay it. I don't want to make the suggestion that they stop cooperating, but in practice, NHSR has cooperated in cases like this that I've been involved in on behalf of claimants, and so Coles and Perfect, a very, very important case. I mean, just let me say this: just because there's a litigation friend doesn't mean that NHS resolution has to pay for the costs of a deputy or court of protection costs. The two things are not the same. Having a litigation friend does not prove that you don't have litigation capacity. Anyone can have a litigation friend, more or less. All it shows is that you basically ought to have an approval, but it doesn't commit any insurer or NHSR to paying out sums for a deputy. And that's all. It's exactly 13:30. But seeing as we started 5 minutes late, then if anybody's got any questions, can they ask them to me? Okay. All right. Yeah, but I mean, basically, if anybody wants to get in touch with me, or my clerks, you know where I am. Okay, all right. Thanks very much for coming, and hope to see you soon.